It's not very often that we can't show you pictures of what we're reporting on, but today, the Supreme Court ruled that violent images, many too grotesque to put on television, may be sold to children. Back in 2005, California made it a crime for retail stores to sell violent video games to anyone under 18. Today, the nation's highest court, in a 7-2 decision, ruled that law is unconstitutional. The games are protected by the First Amendment. Nancy Cordes is at the Supreme Court.
Violent or not, video games are free speech. That was the majority's conclusion today. This country has no tradition of specially restricting children's access to depictions of violence, wrote Justice Antonin Scalia. He and 4 other justices called research linking video games like this to increased violence in children not compelling and indistinguishable from effects produced by other media like books or Saturday morning cartoons.
The arguments that media, especially media that young people are interested in, is somehow detrimental to their development, these are evergreen arguments. And they recur with every institution of new media. They recur with every generation. And so the arguments in the 1950s against comics, those continue to come up. And most recently, they've come up with regard to video games. Now, in the last few years, there's been a push to create laws that would prohibit the sale and rental and display of violent video games and of violent content. And as recently as 2011, there was actually a case before the United States Supreme Court where they were called upon to decide whether a state has the right to expand the definition of unprotected speech to include violent content. And so the kind of moral panic that led to the Senate subcommittee hearings recurred in a way that now they tried to legislate a certain style of speech, not just video games, but violence. And so the Comic Book Legal Defense Fund wrote an amicus brief that was actually cited in the Supreme Court's decision in striking down this California law. It was called Brown versus EMA, and our brief outlined how there is a history of moral panic being used to censor content and that lawmakers should refrain from attempting to curtail and censor speech. And our arguments were actually cited as a reason that this law was struck down, and the panic against comics in the 1950s was entered into the record as something that should not have occurred.